Kim-Thao. I am a research assistant at EuroExperts. Last year, I have collected data concerning the practices and appointment of cultural experts in several European countries. I am also a PhD researcher and a teaching assistant in legal history at Université Paris-Nanterre and at the University of St. Andrews. So that's why I'm very interested in the dynamics between law and cultures. So I am very grateful to Livia, Noura, and the EuroExpert team for the invitation. So I will present quantitative data and qualitative data on 4 countries: Austria, Germany, Belgium, and the Netherlands. So to the Austria survey, there were 142 responses, of which 62% were judges, 5% were lawyers, 27% were experts, and 6% were beneficiaries. To the Germany survey, there were 504 responses, of which 96% were judges, 2% were lawyers, 1% were experts, and 1% beneficiaries. To the Belgium survey, there was a total of 59 responses. 81% were judges, 2% was a lawyer, 14% were experts, and 3% were beneficiaries. And to the Netherlands survey, there were 41 responses, of which 70% were judges, 17 lawyers, 59 experts, and 7% were beneficiaries. Then we move to the perceptions of cultural expertise usefulness. So the most common response to the question regarding the usefulness of cultural expertise in Austria was moderately useful with 36%, followed by very useful with 28%. In Germany, the most common response was moderately useful with 38%, followed by very useful with 24%. Like Austria, Germany belongs to the light orange group. This shows a low appreciation of cultural expertise by German and Austrian judges. In Belgium, very useful and moderately useful come first with 38%. Belgium is in dark orange. In the Netherlands, very useful and slightly useful come first with 29% each. So as we see, these tend to suggest that there is also here a large gap in the awareness of cultural expertise among Dutch and Belgian judges. If we look at the frequency in Austria and in Belgium, we see that in Austria, to the question of how many experts did they instruct annually, most responding judges and lawyers, 52%, has no experience in appointing cultural experts. And the huge majority of those who have already appointed cultural experts did it only less than 10 times. For Belgium, most responding judges and lawyers had instructed experts in less than 10 cases, with 57% of the respondents, followed by never instructed experts with 25%. Overall, Belgian respondents have experience, although small, and more than Austrian ones. If we look at Germany and the Netherlands, we see that in Germany, most responding judges and lawyers, 56%, chose less than 10 times. This shows that, like Belgium, a majority of respondents in Germany has experience in cultural expertise, although small. Nevertheless, there is still a large percent of respondents, 41%, who has no experience in appointing cultural experts. For the Netherlands, most responding judges and lawyers, 66%, replied less than 10 times. The Netherlands is also the country which has the smallest number of respondents with no experience at all. And by comparison with Austria, Germany, and Belgium, the Netherlands has a large part, 66% of the respondents, who has experience in appointing cultural experts, although small, as it was less than for 10 cases. This experience of cultural expertise in the Netherlands could be actually explained by the new reforms in criminal law that appeared in 2010, after that some investigations found that the expert did not have sufficient expertise in the field they operated, or did not have any expertise at all. It was therefore decided that new criteria were necessary to guide the judges in determining the criteria and conditions on who can serve as an expert. And as until 2010, no national register of experts existed in the Netherlands. And on the 1st January 2010, a new law, the Expert Witness in Criminal Cases Act, introduced a national public register of expert witnesses. If we look to the typology of experts, in Austria, the most common response was over with 36%, followed by native language speakers with 26%. Amongst the university professors, who represent 19%, the most common disciplines are sociology and anthropology, both 22%, followed by law with 17%. This may not be surprising, as typical cases are refugee and asylum and immigration law cases. For Germany, the most common response was over with 43%, and to the difference of Austria, where appointed cultural experts come from sociology and anthropology, most of German appointed experts are educated in law. In Belgium, the most common expert type was native language speakers with 46%, followed by translators with 34%. Compared to the 3 other countries, Belgium has the largest number of cultural experts with an expertise in language. For the Netherlands, most of the experts were native lawyers with 50%, to the difference of the 3 other countries, which rarely appoint this type of experts, 5%, less than 5%. Regarding the remuneration of experts, in Austria, over half of responses indicated that experts were paid at a standard hourly rate, 55%. Cultural expertise is most commonly financed by courts, 23%, followed by clients, 22% in Austria. And each party has to bear the cost of the expert they have instructed or whose interest the expert is serving. For Belgium, 50% choose over. Indeed, in Belgium, expert witnesses can freely determine their own cost and fees, but the calculation method must be expressly stated. The court may also reduce the cost where, for example, costs have been incurred unnecessarily. In Belgium, it is most commonly financed by the clients, 41%, followed by courts, 21%. In Germany, the remuneration of court-appointed experts is governed by Section 413 of the Code of Civil Procedure, Section 47 of the Code of Criminal Procedure, and the Justice Remuneration and Compensation Act. In Germany, court-appointed experts are paid on an hourly rate by the parties, whereas an expert who has been privately appointed by a party is paid by their respective clients. And to the question on how experts are remunerated, one expert indicated standard hourly rate and another expert chose set price per report. In Germany, cultural expertise is most commonly financed by courts, with 41%. For the Netherlands, over half of responses indicated that experts were paid at a standard hourly rate, with 74%. Cultural expertise is most commonly financed by courts, with 26%. For the Netherlands, but also for Austria and Germany, we see that experts are mostly paid at a standard hourly rate. Regarding the fields of law, in Austria, the most common areas of use of cultural expertise was refugee and asylum law with 15%, followed by immigration law with 13%. There is here a large diversity of fields in which cultural expertise has been recorded, diversity that we will also observe in Germany and in the Netherlands. For Germany, the most common area was refugee and asylum law with 16%, followed by family law with 14%. For Belgium, criminal law comes first with 21%, like in the Netherlands. But in Belgium, we see that there is a smaller diversity of fields of law in which cultural expertise has been recorded. For the Netherlands, criminal law comes first with 26%. We can observe that family law is frequent for all of the 4 countries. Regarding the type of cases, in Austria, most typical cases involving cultural expertise concern asylum seekers and refugees, in particular the individual applications for asylum and appeals after dismissal of such application. These often arise out of concern of persecution because of religion, sexual orientation, ethnicity, or political activity if returned to the country of origin. In several cases, cultural expertise in Austria is provided as language analysis to attest to the credibility of appellants' statements concerning safety norms and custom of a region, or human rights reports on detention in the country of origin. In Belgium, like in Austria, most typical cases concern asylum seekers and refugees, in particular the individual application for asylum and appeals. Data collection revealed that refugee and asylum cases in Belgium involve a lot minors. Numerous cases in Belgium state the fear of persecution, sexual violence if returned to the country of origin, and religious grounds, political opposition, and corruption have been raised in the immigration context. It has also been noted that there are 2 particular types of cases where parties expressly invoke cultural or religious norms: application for marriage, authorization of a minor, and for marriage annulment. In several cases involving Belgium and other countries, in the European Court of Human Rights, Especially in relation to religious symbols and clothing, the Ghent Human Rights Center has been active in producing expert reports. Specific matters on which submission by the center have previously been made include bans on headscarves in Belgian courtrooms, ethnic profiling, and sex and gender discrimination. In Germany, most of the cases concern the need for international protection arising out of threat of persecution on grounds of political opposition. In particular, in Syria, Iran, and Turkey. Some expert reports also address death penalty, risk of torture, and prison conditions abroad. For the Netherlands, the most typical cases concern asylum and criminal cases. We see that there is a general appreciation on the usefulness of cultural expertise among Dutch lawyers and judges, which is illustrated by the many lengthy statements provided by experts for decision on both lower and higher courts. Regarding the out-of-court sites of cultural expertise, in Austria, the most common site is in court, followed by through NGOs. In Belgium, the most common site is in court, followed by in universities and in detention center. In Germany, the most common site was in court. In the Netherlands, the most common site was in court with 29%, followed by out of the court. If we look at the training programs, so for 3 countries, Austria, Belgium, and the Netherlands, I did not find much data about training programs except some private initiatives. But for Germany, human rights law and clinical training with pro bono consultation are gaining foothold in legal education and may encourage the next generation of lawyers and judges to take into consideration cultural expertise. If we look at the main sites and potential models of cultural expertise in Austria, most typical cases are asylum seekers and refugees. Also, appointment of translators and country lawyers. For Belgium, most frequently in criminal law and family law cases. And we note that a majority of cultural experts are native language speakers. For the Netherlands, there is a general appreciation on the usefulness of cultural expertise among Dutch lawyers and judges. Many refugee and asylum cases in those cases, language experts are instructed. For Germany, most of cultural experts are supported by the courts. The appreciation and utilization of cultural expertise in German courts depends largely on the court and even on the judge. Some judges rely on the reports of state authorities, such as the German Foreign Office. And at the lower courts, it is rare that individual experts would be appointed, similarly to Austria.